Good afternoon. My name is Tereposky. I am an employment lawyer with Samfiru Tumarkin in the Calgary office in Alberta. So I do Alberta employment law and human rights associated types of practice to employment law. And hoping today to have some interesting questions to be able to answer on our employment law live stream. We kind of always do, so we'll wait for those to come in and go from there. While we're waiting, I guess I can put in a little bit of a plug for a blog that I just wrote and was put online a little while ago about a recent decision from the Alberta Labour Relations Board, which is the body that we go to when we don't agree with an employment standards officer's decision. And in that decision from the Alberta Labour Relations Board, it was about an employee who was what we call misclassified. So at the time of termination, the employee was told that he was a construction employee, and under employment standards, construction employees aren't entitled to termination pay, so severance. And his employer said, yeah, you're a construction employee, you don't get any termination pay. And the labor board decided that he was not, in fact, a construction employee and was awarded termination pay. So we see that come up a ton in our practice, in Alberta for sure, and I'm assuming likely across Canada, where employees kind of, classify an employers classify an employee as one thing, and they're really, under the law, they aren't that. So construction employees, they get a fair bit. You're working construction, you're not entitled to termination pay. They let you go, they don't pay anything. One thing to think about is you may not be classified as a construction employee because there's actually some factors that go into that analysis. And even if you are a construction employee and you're not entitled to termination pay under the Employment Standards Code, that doesn't mean you're not entitled to severance, common law severance. So, just when an employer tells you that they're not paying you anything on termination and you're a construction employee, it's wise to reach out and get somebody to talk to you about, whether you are entitled to severance, especially if you've been at your job for, quite a long time. These employees that are construction employees and have worked at the same place for, 10, 20 years, and then their employer terminates them and says, you're a construction employee, you don't get anything. That's not necessarily true. So you could be entitled to a significant severance. We also see misclassification issues a lot of times between employees and contractors. And that's another way that employers try to say, well, you're not entitled to any severance because you're a contractor. That's a pretty, detailed and technical legal issue. So, don't kind of take your employer's word for it. Even if you've signed a contractor agreement, a lot of times that doesn't necessarily mean you're actually a contractor. And also good to remember that contractors under the income tax rules are not necessarily the same as they are under employment rules. So even if you're a contractor and you have a contracting agreement and you're, that way for income tax, that doesn't necessarily mean that under employment law that you would still be a contractor. So you could be entitled to severance. So, that's really an issue that, needs to be looked at by an expert. And, if you have a significant length of service as a contractor, a construction worker, it's important to get that looked at because you could have significant entitlements. So I'll move on from that. I could talk all day about employee versus contractor and that kind of thing, but we have some questions coming in. So there's a question from YouTube from Marvin. It says, my employment has included a company car for business use with all expenses for several years, including personal use and gas. The business sold to new owners and they want to limit payment for the car to business use only. What are my rights and what options do I have? So an employer can change your terms of employment. There's just, they have to do it properly. And if it's a significant change and they just unilaterally change it, or a material change, it could be a constructive dismissal. So they have to be careful with that. If that's a significant part or a material part of your compensation, then that could be a constructive dismissal, which would basically mean they're terminating the employment contract, and that entitles you to severance. They don't really terminate the employment contract, but a constructive termination that entitles you to severance. So you could take the position that your employment has been constructively terminated and try to get severance, but that means you're resigning on the basis of a constructive dismissal, basically. They can change the terms also properly if they give you notice of the change and a proper amount of notice, which usually is about the same amount of notice you would have to have if you were actually being terminated from your employment, or by getting you to agree to it. And you have to be careful that you're not implicitly agreeing to it. So you have to, if you don't agree, you should make sure that you're documenting that you don't agree, in writing, probably via email. And that would mean you could preserve your right to raise that constructive dismissal allegation later on if you wanted to. But I mean, in general, employers are able to change your terms of employment. It's just what recourse do you have for that change? So if it's a material change, if that's a significant part of your compensation package, you could be entitled to severance. Next question. Wait, that's the same question, I believe. Yes, it is. So we'll move on to the next one after that. How do you know what your job classification is? Okay, so we're going back to my rant on job classification before we started. Sorry, I have my dog is hanging out in here. So generally, most people are employees. You would probably know if they're classifying you as a contractor. Usually, if they classify you as a contractor, you have a contractor agreement and they don't withhold any tax or EI or anything from your paycheck. So they would just be paying you and not doing those withholdings, and you'd be responsible to do those yourself. That's sort of the employee versus contractor piece. As far as construction, I mean, if you're working on a construction site, there's definitely, you probably are a construction employee, or in the construction business. And that was the case that just went to the Labor Relations Board. He was working in a construction business, but he wasn't really working on a construction site. He was a truck driver, and so he was delivering construction materials. And that's why they decided he wasn't actually a construction worker. So, as far as employee versus contractor, you would know. Probably if you were a contractor, most people are employees and most people are classified as employees. If your employer is going to try to tell you you're a contractor, you would likely know. You'd probably have an agreement and you'd probably not be getting deductions made from your pay. I have another one coming in from YouTube from Richard. I work as a truck driver for a local siding company. They are shutting down our location, but HR is saying because I work as a driver, my severance entitlements are different. Is that true? I've been there for 8 years. So that's actually super similar to the case that I was just talking about. That gentleman was also a truck driver. So you might want to just, do a search and find my blog online. You could read through that and see if that, is sort of similar to your situation. It has a link to the actual decision. But it's really similar. If they're telling you that your severance entitlements are different, they might be saying that because you're a construction worker. So they might be saying, well, because, it's a siding company, we do construction. And therefore you're a construction worker, so you're not entitled to termination pay. You're saying they're telling you your severance entitlements are different. So I don't know if maybe they're saying they're different from the other employees that are construction workers. I'm not 100% sure what you mean by different, but if you've been there for 8 years, generally your entitlement to termination pay would be 6 weeks if you're over 8 years. If you're just under 8 years, then it would be 5 weeks, but you could also have common law entitlement. So I would say for common law entitlement, if you want to take a look and see, how much you could potentially be entitled to, we have our tool online, our Pocket Employment Lawyer, which is like a severance calculator, and you put in your factors, and that could let you know, how much you could potentially be owed. As far as, the different entitlements for a truck driver, I mean, usually that's not something that would give you different entitlements. It would be a construction worker or contractor. So I would need a few more details, but the Pocket Employment Lawyer might be a good place to start for you. I have another question from YouTube. I'm dealing with an escalating problem with my manager. He's very verbally abusive. How do you deal with harassment in the workplace? What is the best process out of just telling HR? Well, I mean, some companies, and depending on your company, will have sort of like a phone line that you can phone in anonymously and report these kinds of issues. If you don't have that, obviously HR is an option. If you feel comfortable, you can try to, broach it with the manager himself. I think it was him. But really the steps to follow, or what's recommended in these types of situations, is to document everything, because it could get to the point where you need to allege that you've been constructively dismissed for the creation of a toxic workplace, and you're going to need to have some evidence of what has happened. So my biggest recommendation is to document everything. So keep a diary or a journal and write in there all the time, every day, what's happening, what time, where, who was there, so that you have that evidence later on, because the courts consider good evidence to be something that's recorded at the time that it occurred. So it's really a lot better to have that written down, as you go, rather than try to think of what happened later on when you have to go to a lawyer and talk about it. So as far as escalating it, the way to do it is to go through HR. That's the first place to start. If it doesn't work, then, and it's getting worse, you may want to look at constructive dismissal. So you may need to come talk to an employment lawyer. So, reach out to us. We're here to hear about issues like that and give you advice on, whether or not it's time to allege a constructive dismissal, make a complaint under OH&S legislation, or, what to do with that. So I hope I answered that for you, and I hope that's helpful. Next one is from YouTube, from, looks like, Ryan. Hello, I'm returning from work injury. My employer extended a new transition contract that they said will be a permanent demotion, and said I can apply for my PIJ. Is this a human rights violation? I'm trying to think of what PIJ stands for. It's not coming to me, so I'm not sure on that one. Permanent demotion, if you're returning from an injury and you're not able to do your pre-injury work, an employer has an obligation to try to accommodate that injury. And if you're unable to do that work, then they have to look for another position for you. So if the only option is another position, they, under their duty to accommodate, that might be all they can do with you. So if it's a demotion, there's a possibility that you could argue that it was a constructive dismissal because they've changed a key term of your employment. But if it's their only way to accommodate you, usually that's a good defense for an employer. So that question has already gone away, so I'm not sure what the question was at the end of the paragraph there. But I mean, those are kind of the things to consider. If you're coming back and you're being demoted, you could be in a constructive dismissal situation. But if you're not able to do your pre-accident work, and that's the only place that they can put you, then that might be the only acceptable form of accommodation under human rights law. So those are kinds of the things to consider. If you have more questions about that, again, reach out to us and we can have a further conversation. I have another question from YouTube. My employer is asking me to resign upon returning from maternity leave. I worked in a remote position prior to my leave. They outsourced my job to an agency. If I resign, do they owe me anything? Yeah, don't resign. If you do resign, yeah, they aren't going to owe you anything, although a resignation does have to be voluntary and unequivocal. But if they ask you to do it and you send an email saying I'm hereby resigning, I mean, that's good evidence that it's clear and unequivocal. If you're being asked to resign, they can't make you resign. You can say, well, I'm not resigning, so what are you going to do with me? They can't make you resign. And if you do resign, they don't have to pay you termination pay. You're not owed severance. So, it's not a good idea to resign. If you worked in a remote position and they outsourced it while you're on maternity leave, honestly, they're in violation of the Employment Standards Code, because they are supposed to return you after your maternity leave to your position. And if they can't do that, then they have to put you in an equivalent position, or they're in violation of the Employment Standards Code. If they've outsourced your position while you're away and they need to now terminate your employment because they have no job for you, then they need to terminate your employment and provide you with severance. They can't make you resign, so don't do that. And if you want to talk about that further, definitely reach out to one of our lawyers, because that's not a good position they're putting you in. There's human rights implications. There's Employment Standards Code problems there, and there's severance issues. So there's a lot to unpack in that question, and you could definitely be entitled to severance there. Okay, question from Reddit from Carrie. I was terminated from my job yesterday without cause after 3 years in my role. My contract includes a clause about terminations, and I'm wondering if it's worth speaking, and it cut off speaking to a lawyer. Termination language is super complex area of the law. It's very technical. It may say that, you're only entitled to employment standards. It may say that you're entitled to, 1 week per year of service or something like that. And it may say that you're not entitled to common law severance. But I will tell you that there probably 3/4 at least, maybe more, of the termination clauses I see have issues. Like they're potentially not going to be enforced by the courts. So, if they're providing you with a very small amount of severance, and maybe you've gone on and done the pocket employment lawyer and looked at that calculator, and in your common law entitlement to severance would be a lot higher than what they're offering you, then get that clause looked at. If you're getting shorted, then it may be that clause is not enforceable, and it's hard to tell if you're not an employment lawyer, because it is pretty technical. So I would say it is worthwhile to speak to someone. From John on YouTube, my company is in the process of being purchased by another company. I've been working at this company for 15 years. I have another offer from another company, but should I wait for them to sell? Well, I usually tell people that, having a new job is better than waiting around for severance, but I guess it depends on your timing here. If, you think that this is going to kind of wrap up pretty quickly, and they may be severancing you out because they're, in the process of changing over, it might be wise to wait for your severance offer and, wait on starting the new job if you can. However, if the company is being purchased, what they might do is just bring you over into the new company. So there may not be a severance offer coming. And if you want to leave, it might be best to just move on to a new job, which could be better. So I think there's, quite a few factors that go into that decision that maybe, are details that I'm not aware of in the text of that question. But hopefully I've answered that. I think that, if you think that, this is going to wrap up really quick and there's a severance offer coming, then maybe wait for that before you start your new job. But, if there's a possibility they're just going to transition you over, or if you think that's likely, then, there's probably no reason to wait around, because you're not going to be entitled to severance if they're just continuing your employment into the new job. I have another question from YouTube. This one's from Darlene. If an employer makes changes to their sick leave policies while you are off on leave, can they use these new policies to let you go when you return? Okay. That's an interesting one. I'm trying to think of what kind of changes they could make to a sick leave policy that would justify them in letting you go when you come back. When you're off on a medical leave and you have submitted a medical note from your doctor saying, I have to be on leave for this long, one thing you have to keep in mind is that is a job protected leave under employment standards legislation. So you have 16 weeks per calendar year that you are protected from losing your job under the Employment Standards Code. And that's per calendar year. So if you go on leave on, December 1, it restarts on January 1. So it'd be 4 weeks, and then you get 16 weeks starting the next calendar year, even though it would be like a 20-week consecutive leave. So, that's outside of any policies. They can't violate those policies. Also, under human rights legislation, they can't terminate your employment because you're having medical issues if it's a disability under human rights legislation. So it seems strange to me that they would change a policy that would allow them to let you go. If it's not related to the disability or to the reason that you're on medical leave, then I guess it's a different situation. But I don't know that the timing of the change to the policy, would assist them. I would need to know more about what these changes are, because I can't imagine. It's hard for me to imagine a change to a sick leave policy that would allow them to legally terminate your employment as soon as you return. So in general, I would say the answer to your question is likely no, but without knowing what those policies say and the specific details, it's difficult to imagine how that would work. Ryan's back and he says PIG is pre-injury job. Okay, so PIJ. Sorry, that abbreviation didn't come to my mind right away when I was reading it. He says, I'm medically cleared to return to my pre-injury job. The employer said they don't have any obligation to reinstate me. They did not consider, it says the employer did not consider me for a suitable alternative job I have requested and qualified for. They said they have no obligation to reinstate me. Is this legal? That does not sound legal. That sounds like a violation of human rights legislation. What happens sometimes is that employer, especially if you're on WCB, and I don't know if that's your situation, but a lot of times what WCB does is they tell employers that they don't have any further obligation, and that sometimes is true under WCB legislation, but it's not true under human rights law. And I've had many, many employers who mess that up. So they tell their employees, we don't have to bring you back because WCB says so, but WCB doesn't advise them on human rights legislation. And under human rights legislation, you can't be let go due to a disability. So if you have a disability and you come back, and they lay you off, there may be a human rights violation. Also kind of depends how long you've been off, because there's an obligation to reinstate under Employment Standards Code within that 16-week leave. So it's definitely sounds fishy. I would want to know some more details about timing, what the injury is, if they've tried to accommodate at all. I think that you need to reach out and get some advice on that, and you could have entitlements, especially if they're not properly accommodating you. Question from CJ on YouTube. My employer changed their policies while I was off on medical leave due to an injury I sustained on the job. The policy limited the number of days you could be sick or late to 3 and 6 months. Because I needed to take time off for medical appointments, they let me go. I worked there for 20 years. Is there anything I can do? Yes, definitely reach out to a lawyer. Allowing a termination because someone took 3 days off that, first of all, I'm not sure if you're saying that that's a termination without or with cause. But there's a severance entitlement there, even if you are let go. I also think that if your injury would qualify as a disability, that there's human rights violation issues there. Definitely sounds like something is very wrong there, that they're, creating a situation where you have, they have the ability to terminate you because you had a medical issue. Sounds like a very, very obvious human rights violation. So those policies, keep in mind, an employer cannot contract out by making a policy out of employment standards minimums or out of human rights legislation. They can't just make a policy that allows them to violate your human rights or violate the employment standards code. So I think, you need to talk to somebody about that. That does not sound, doesn't sound very, very above board at all. Got Darlene back. I'm not sure if Darlene and CJ are the same issue, or they just have the same person, or they have a very similar issue, because it is really similar. Darlene says they're changing the definitions of leave types, and what needs to be sent is in as an accommodation request officially. It seems to me that if you were already on leave, you should be governed by the policy that was in place at the time you went on leave. in order to change a term of employment, there needs to be some sort of notice given. So, if they're changing it after the fact, I don't see how that would apply to you. Yeah, that seems awkward. And I'm not sure if this is the same problem as the limit on the sick days. So if this is two different people with very similar issues, I would definitely have, get this looked at by somebody, because I see some human rights violations here. Johan says, what determines receiving a minimum versus a maximum payout? So there's not really a maximum payout. That's not really a thing, but a minimum payout or minimum termination pay is what is required under employment standards. So what that means is that an employer has to pay those minimums. They're statutory minimums, but they're only minimums. So when you're terminated without cause, the employer has to go to the Employment Standards Code and they look at how long you've been working there. And they look at the Employment Standards Code and it sets out, basically I have it written right beside my computer screen. For 90 days to 2 years, the minimum is 1 week. For 2 to 4 years, 2 weeks. For 4 to 6 years, 4 weeks. 6 to 8 years, 5 weeks. 8 to 10 years, 6 weeks. And 10 plus years is 8 weeks. Those are minimums that have to be paid no matter what. Maximum payout isn't really a thing, but the other type of severance you can get is common law severance. So that's separate and apart from those minimums. The minimums have to be paid. Now it's, are you entitled to severance per the common law? The only way you're not entitled to severance under the common law is if you have an employment agreement that's properly drafted, is not vague, is not ambiguous, that where you have agreed that you're only getting employment standards minimums. Those are rare. Not that many employment agreements pass the test of being vague and unambiguous, so that they actually do restrict you to employment standards minimums. And most people don't even have employment agreements. And if they do, they don't have termination language. So most people are entitled to common law severance. What common law severance is depends on a lot of factors, right? So there's not really a maximum payout, but there's an amount of common law severance that applies to each individual. The way that's determined is by looking at years of service, age, availability of similar employment. And those are the factors that go into our pocket employment lawyer, our severance calculator that I've referred to a few times. And you can take a look at that and see what your common law entitlement might be to severance. So I hope that answers that question. The determination between getting the employment standards minimum, everybody gets those unless you're terminated for cause. Maximum or common law severance, the only way you don't get those is if you have an employment agreement that says you don't get them, and it has to be very, very well drafted. Had a couple more questions here. We have a few minutes left. So from YouTube again. Oh, from Reddit, sorry. My employer has said that if I relocate back to the East Coast, I'll be considered resigned, abandoned. I work a remote position, was told that I cannot move. Can my employer force me to stay in the province? Can they require you to live in certain areas if you're a remote worker? I mean, if it is a term of your employment that you have to stay in a certain area, an employer can impose those kinds of terms on your employment. If you had a term of your employment that said you could live wherever and work remotely, and they're changing it, then that's a different story. But I'm not sure if what you're saying is that there was no term and you were able to, and maybe other people live outside the province and work remotely, and now they're changing that term, then there's only certain ways they can do that. If they're just imposing that now, that's different than if that was always a term, and then you're trying to function outside of that. So can they require you to live in certain areas if you're a remote worker? I would say they can, but it has to be contractually agreed to and properly implemented. My employer has said that if I really, okay, I just read that one, sorry, same question. And then Johan's come back with, how do you know if your contract limits your severance entitlements? Well, you have to read through your employment contract. Usually there's a clause that's entitled termination or something like that. And it'll say in there, if you are terminated without cause, something about you are entitled only to the minimums under the Alberta Employment Standards Code. So look for that language in your employment agreement. Like I said, it's really hard as a non-employment lawyer to determine though whether that language is going to be enforceable. It's very technical. So if you do have that kind of term and you think that, you know, you would have a pretty good entitlement, reach out, because you need to have that looked at by an employment lawyer. Those arguments as to whether or not that's enforceable are really technical, and honestly, most of them aren't enforceable. So I think we've hit our time here, 1:30, so we have to sign off. Hope everybody enjoyed today, and I hope I answered all your questions. Thanks a lot for the questions. Obviously, it would be a pretty boring session if nobody asked any questions, so I appreciate that. And tune in tomorrow. We have Leo, our founding partner, who's at 1 o'clock Eastern time with an employment law Q&A. Thanks, everyone. Have a good day.